Okay, today we'll be discussing about a simple case study of a legal opinion. Tomorrow, when you face a similar type of clientele, you can give advice on the similar lines. So today I have one of the client had approached me to give a legal opinion over purchase of a apartment in one of the apartments. So here he had given me a document of sale deed, khata certificate, tax paid receipts, and one letter issued by the builder for a car parking allotment. So now, how should we verify whether the property is in his name or not, and what legal opinion and how you should draft a legal opinion when giving an advice to a client? So those aspects we'll be dealing in this seminar. So first thing, when I have obtained the sale date, what I will need to verify, I have to briefly make a note down of. I have briefly. Yeah. Yep. Thank you. So firstly, we need to write down few things from the sale deed. So first we need to check the parties' names. So third or fifth page, there is a rectangular box which contains registration numbers. We need to make a note down of that. We need to check the schedule of the property. The property, the question in which property is he selling to the purchaser, that property, is it available in that sale deed? We need to make a list. So we need to check in the last 4 or 5 pages under which all schedules the property is existing. Generally, Schedule A contains the entire land. Schedule B contains the UDS, undivided square feet area. How much of land area the purchaser will get when he purchases the apartment. C is the Schedule C generally will be shall contain the apartment square feet area and what other details, and also it may contain parking, one covered parking mentioned in Schedule C. Sometimes when apartments are formed, they will also issue Schedule D and Schedule E. Schedule D and Schedule E sometimes contains rights of the purchaser, duties of the purchaser, obligations of the purchaser. These things in the Schedule D and E it may be containing. So here have barred all the numbers of the sale date, so to maintain the client confidentiality. So here we need to observe, as stated earlier in the earlier slide, we need to make note down of the parties' names. The parties' names are available in the first and second page. So we make a note down of this in a separate sheet when we write down. And on which date it was executed, we make a note down of the same. And then this slide actually contains how much of stamp duty you need to pay when you purchase a property. Generally, in Karnataka, the rates are 6.6% of the stamp duty of the consideration value. For example, you are purchasing a property of 50 lakhs or above. You need to pay a stamp duty of 6.6% of 50 lakhs to the government. So generally, the earlier the system used to be, the purchaser had to buy demand drafts in name of such sub-registrar office to make payment to the government. So the same details are entered in second page of the sale deed in this format. The backside of the sale deed is printed with the amount you are making payment through demand drafts. So 6.6%, it has various, it is divided into various sectors for stamp duty, for registration fees, for Swachh Bharat cess. So different on different aspects you would have raised, you would have purchased different DDs. But now on today's date, this practice has ceased and it is not in existence. Today, if you are purchasing property, then you need to make payment directly online In the government's website, there is not getting the name of the website. If you're purchasing a property, you need to make stamp duty payment on that website to the government directly.
Khajane.
Yes, correct, sir. Khajane 2. So on Khajane 2, you make stamp duty payments. So once before when you're advising a client, before I always suggest you visit the sub-registrar office and you show him the draft of the sale deed, what you are about to register, and get an estimation like how much stamp duty on which all heads you need to make payment in Khajane 2. So once you get that estimation, you come home, you go online on Khajane 2 website, enter all the property details and enter the values. So when you enter the values, the sale consideration value, different denomination you have to enter on different payments. So once you click online payment, so those payments will go to such departments. Swachh Bharat says one department will be there. Stamp duty for government, it will go to government department. Registration fees, it will come to the registrar office. All those details, it will go into such accounts. So after this is done, the next day you go for sale deed registration with both the parties. And there also, once you enter all these denominations, the same data entry is done by the case worker who is in the sub-registrar. He will enter all the details of your payment details, your names of the parties, property details. Once he enters the values there, and the receipt number generated when you make online payment, the same online payment receipt number will be acknowledged by the software, and then it allows the parties to register the document. Now they have made it very easy. Earlier it used to be demand draft system. Now the system is changed. You have to make payment online in Karnataka when you purchase a property. So whatever the receipt number, whatever you enter and whatever values you enter should tally there. It should not be 1 rupee. Even if it is 1 rupee less also, it will not accept the property for registration. So the value should be in proper. It should be, even if it's 1 rupee more also, not a issue, not a problem. Coming to my next slide. So as when you are giving a legal opinion, you should also make a note down of this 4th page, that is this rectangular box, which contains all the registration details, CD number, the property registration numbers, on which date it was registered. So you need to make a note down of all these details. And last important thing, when you look for a sale deed, you need to check for the schedule A, B, and C property, whether the property you are buying and the flat number and all those things, and which tower, which apartment, which block it is situated. All those things you need to check. Schedule A, schedule B, schedule C, whether all is in confirmed to the property the purchaser is about to buy. So here I made a note down of all these things. Now I will have to cross compare all this data by, I will before I cross compare all this data, I will take all these details from the sale deed. I will apply for encumbrance certificate form number 15. So now EC encumbrance certificate you also need to apply online. Suppose let's assume the property is, let's assume it's a resale property. The purchaser has purchased in 2011 from the builder, and he's selling it in the year 2022. So 2011 till 2022, from the first sale and till the second sale, are there any transactions? How you need to find out is by applying encumbrance certificate. So you need to apply encumbrance certificate for the years 2011 till 2022, or with particular dates. Okay, let's assume it's purchased in 2011. I will apply from a time frame of 1/1/2011 till the present date, 31/7/22. I have applied online for encumbrance certificate. Now I will tally all those details in the sale deed. verify the property details from column number 2 with the sale date. In column number 2, generally the property details is typed. So in whatever the schedule A, B, and C, whatever is mentioned in the sale deed, the same data shall be available in column number 2. So date and market value on the date, which date it was registered. This property was registered on a particular date on so and so in 2011, and it was purchased for X values, 50 lakhs or 51 lakhs. Those details will be available in column number 3 and 4. In column number 5 and 6, so who is the party selling and who is the party purchasing? In 5, selling parties' names will be mentioned. In column number 6, the purchasers' names shall be mentioned. So the registration number, so the numbers which I told you, which will be available in the rectangular box, you need to cross verify with encumbrance certificate if those same numbers are available in sale deed and the encumbrance certificate in column number 7, 8, and 9. So let's look into. So what is the importance of this document, encumbrance certificate form number 15? So this certificate gives us the history of the number of transactions done over the property. So it will show us loan details, the change of hand, how many hands have changed, if the purchaser has gifted the property to some other property, or if he has mortgaged that property to the bank, or if he has done deposit of title deeds in a bank, or if there is any court order of court orders or some stay over sale of property, all those things is available. Partition of property, if there are many brothers and they want to do they have done a partition over the property, and if there is any joint development agreement, registered sale agreement, all this data you can pull out from this form number 15 after applying. So on it's a case-to-case scenario. If you are applying for a land and all, you will get all data of joint development agreement and all those things. Some data may not be available when you apply for an apartment. So when it's directly you're purchasing. And also please make a note down, general power of attorney and will, these details about JPA and will are not available in this certificate because their book numbers will be different. So you need to know which what data you need to entry if you want to find verification. Is there a power of attorney or a registered will existing on that property? So different data you need to enter over that property, and you need to check the book of records in that sub-registrar office. So here is a sample example as stated. So the column number 2 contains all the apartment details. Column number 3 and 4 contains the date of when on the dates on which all dates transaction has happened. Suppose the 3 hands have changed over property. There have been 3 sale occurring. On which dates it was occurring? Column number 3. So you will check in column number 3 on 2019 one sale happened, and in 2020 another sale happened, 2021 another sale happened. All those details will be available in column number 3. So column number 4 will tell you about the market value, for which all market value he has sold on the previous years. So column number 5, Baredu Kottavaru, that means the person who is selling the property, his name will be available, and subsequent sellers' names will be available. Bareisi Kondavaru, column number 7. Sorry, column number 6. In this column, the person who is purchasing the property, his details will be available. So subsequent purchasers details will be available. 7, column number 7, 8, 9, the rectangular box which I mentioned earlier, those details you need to apply encumbrance certificate. You need to cross verify from this column number 7, 8, 9 whether all those such numbers are matching with the concurrent sale dates. So once you apply from so many dates, suppose for example here it is mentioned 1st April 2011. I have applied from 1st April 2011 till 26 July 2022. So in this time frame, how much transaction has happened over the property, you will get the entire details in this encumbrance certificate form number 15. So the next important document we need to ask from the seller. Suppose some purchaser has approached you and you have to give a legal opinion. So after a purchase has happened, the purchaser should go and change the khata from the builder's name in the buyer's name. So he should have done that process. So this khata ensures as per law that he is in possession of the property. Just by having a virtue of sale deed, the law does not assume you to be in possession. The law assumes you to be in possession only when you have changed the khata from the builder to your name and you have paid property tax till date. That is the time when law assumes that you are in possession. Tomorrow you have to file a case or somebody is disturbing your property. Again, the court will ask you, how are you in possession? Have you, is the khata available in your name or have you paid property tax up to date? These questions will be, you have to answer before the court. Yes, I have, the khata is in my name. I have been paying property tax up to date. I am in possession. So paying property tax and having khata certificate in the purchaser's name ensures the purchaser that he is in possession of that property. So this khata certificate ensures that he has generated a property number, account number with the government. On that number, every year he will pay taxes to property. So with this document, so when he wants to further sell this property, the sub-registrar has to inquire whether has he paid property tax till date. Only on such payment of property tax and such khata certificate being available, then only he will allow the property to be sold to another third party. So this is one sample example of khata certificate made in the Bangalore rural area. It's one of the khata certificate issued by Mandur Gram Panchayat near our college. So one example of how a khata certificate is available. Khata certificate, generally the purchaser's names shall be provided, because here the purchaser, we can see that after he has purchased from the builder, he has obtained khata certificate in his name after paying 0.2% of the 50 lakh or 51 lakh. Generally, there is a fees to be paid to the government. Generally, it is 0.2%. So this is Bangalore rural. So the rates may differ from city limits and to rural limits. So here we can see there is one property number issued. Actually, it's in this column. If my pointer is visible to everyone, generally it is available in that column, the property number. On that property number, a government account is opened on which you pay property taxes annually. So this is one of the receipts in rural Bangalore rural level. They issue handwritten receipts. So the number what I was mentioned about the property numbers, this is the number which shall be a this number shall be available on that khata certificate. On this number, every year you pay property tax. So here we can see the purchaser has paid property tax till 2022-21. So previous years he has paid property tax from the date of purchase. So now when we have to draft a legal opinion, now I have received all these documents I have received is to give a legal opinion. I have received sale deed, I have received khata certificate, I have received tax paid receipts, I have applied for encumbrance certificate form number 15 to verify whether all those details submitted before me is it true or not. And I have also obtained one letter from the builder for issuing a car parking. So now what is the role of an advocate when he gives a legal opinion? So first he has to check whether in whose name the property is available, and he has to search all the rights created over the properties. Any transaction has happened in that duration when the property after the date of purchase by the previous purchaser, any transaction has happened, he has to verify through encumbrance certificate. After verifying, he has to draft a legal opinion. He has to give a title certificate in whose name the titles, the ownership is existing by verifying through encumbrance certificate and sale deed. So one more, when it's in apartment association and all, whether has he paid any maintenance dues, and he should also have obtained no objection certificate from the association to sell his apartment. So without property tax being paid till the present year, the sub-registrar won't allow the property to be registered. So it is a must that property tax has to be paid till the present year. So coming to drafting of a legal opinion, here I have showcased you a simple legal opinion which I have drafted. So here the list of documents I have initially mentioned to whomsoever it concerns, because whoever is purchasing the property, it should be a generalized legal opinion whenever we write a legal opinion. So anybody can verify all the details. I have verified so and so copies of online documents of apartments, because we are not getting original documents. If we get original documents, we have to mention I have verified original documents. But when we are getting copies of documents, copies of online documents, we have to mention copies only. So and so I have verified the following copies of so and so online documents situated at so and so floor. So I have mentioned the list of documents produced before me. So sale deed is produced before me, car parking letter is produced before me, khata certificate is produced before me, tax paid receipts is produced before me, encumbrance certificate I have applied it on my own. This is the only document I have applied of the one in the schedule of the property. I have mentioned about the flat details. So flow of title. So this para is very much important. So suppose there are change of hands, you need to write a history about how many hands have changed. Is there any loan on the property, or whatever mortgage has happened on the property? You have to make a clear flow of title and what all rights have been created. So it is very much clear. So here the proof of sale is available because I have applied for encumbrance certificate for the years 1/4/2011 to 26/7/2022, issued by so and so sub registrar office. It confirms a sale deed was made on 11/2/2019 by one of the builders in favor of so and so person. So further, the purchaser has applied for khata certificate, and he has also obtained khata certificate form number 9 through Mandur Gram Panchayat, and it shows that property uh, khata certificate is existing on his name, and he has also paid property tax up till 2021. So now I have to give a legal opinion that this so and so property is belonging to such and such person, and I should also certify that so and so owner has the necessary rights to sell, lease, mortgage, or create necessary rights over the property. And we should also mention that the property tax was paid only till 2021. We should also ensure that the property the seller has to pay property tax till the year 22 to enable the scheduled property for registration or sale purpose. So this is my simple legal opinion I have drafted, and I have given it to my client for an apartment. So any doubts from this session I would like to answer? This is, yes.
Sir, let's say after taking our legal opinion, something happens to the property, like some OS or some stay order comes to the property, can they come back to us and ask us about that, or in any way legally sue us for that, sir?
Generally, we advocates restrict our scope for the documents produced before us. It depends upon what type of legal opinion a person is asking for. Sometimes a builder is purchasing a property. He needs a detailed verification. Okay, for that we need to do a detailed verification, and you will be obviously taking a hefty fees. When it depends upon the type of client you are handling. If that person is willing to pay a bigger fees and you have to run through several offices and you do a detailed verification, that's feasible for that type of client. So it's on client basis what type of uh, verification he wants. He just wants you to verify on the copies given to him. We give it on the copies given to him, and if he wants us to give do us a detailed verification by approaching different officers and applying copies of those same documents, then a different verification needs to be done. It depends upon the client's requirement when you give a legal opinion.
They cannot come and question us later if at all something happens.
I have given my legal opinion only based on the documents you have submitted before me.
Okay, sir.
Understood?
Sir, one more doubt I had. Sir, when it comes to apartments, there is something called as this RERA, and other one I have heard about OCCC, all that, and that other one is the deviation project. Our deviation projects, they get registered in the sub-regional office now, sir. For that also they take legal opinion. Is it valid or legal to do that?
Bangalore, what happens? Most of the projects which are come up, they would have not constructed as per the plan sanction. They would, if more than 5% deviation is made in the construction, such deviation is not allowed and they are not being given occupancy certificate, because there are three stages when the builder approaches to obtain plan sanction. First is commencement certificate. So when he starts the construction, that is the time he obtains commencement certificate. After that, when he finishes the construction, he obtains completion certificate. And after that, when the building or the apartment is good enough for any family to come and occupy and live in, it's in a condition to have a habitable condition, then they issue occupancy certificate. So this is the stage where the builder does golmaal, and he only gives you the completion certificate and not the occupancy certificate. But still, the builder has a right to get the apartment registered in any of the purchaser's name, but it does not bar him to sell. Here, our state government has to change laws, that they have to change laws and make strict compliance. Only when OC is issued, he should be permitted to sell. If such kind of conditions are imposed, what you are saying will be applicable.
So in sub-registrar office, they usually don't ask for that OCCC also directly, just
Yes,
with the team there.
if a state, that's the work of state government. They have to they have to change the law and bring a notification into that effect. Correct?
Yes, sir. Understood, sir. Thank you, sir.
Sir, I have a question related to one of the consideration most of the peoples have, that banks like SBI, if they are releasing the fund on the loan, they verify all those things of legal requirements already. Is it true, sir?
Yes, they also do. Generally, they also do verification, but generally it's safe always to get it from a advocate, because if the client wants to do a thorough background check on the land and other things, because banks will only check on the apartment construction type, whether it is under the
Okay, sir.
many
And
banks check.
I
But But
Yeah,
when
I have
you
a
have,
second. Yes, sir.
but
And I have
when,
another question
yes,
on the what is the name of in other state we refer the Khata certificate with the different names. So what is the standard name for every state, sir?
different states have their different language
Like
terminology.
in Maharashtra, it is called as 712 something, Satbara. And some other state is known with some other names also. So do we have some standard name across pan India?
There is no standard name available. Generally, it is, we can only say property tax, property certificate or property tax receipts. These are common English terminology used instead of those regional languages used in such states. Many states we have followed from British era, and British have accepted some terminologies from the regional language, which is understandable for the local crowd there. Such
Right,
terminologies
sir.
have been in existence.
Right, sir. Right.
So here
Thank you,
today
sir.
we have discussed only in Karnataka's aspects.
Okay, sir.
So one more doubt, sir. Sir, you were telling about the consideration, no, sir, that you have to pay TDS or something after if it crosses 50 lakhs.
So for 50 lakhs, 1% should be deducted from the sale consideration value. Suppose you are purchasing the property for 51 lakhs. So for 51 lakhs, 1% you will not pay to the seller. You will only pay him 49, 49 or 50 lakhs. The remaining 1% shall be paid on his PAN number to the government. Tax deduction at source. It is like
Sir,
seller is getting the benefit of the capital amount on sale of property. So the government has to, instead of collecting from his income tax, it is directly collecting from at the time of registration. He can get a income credited for that show of 50 lakhs or so and so amount.
yes, sir, I understood that, sir. But I understand there's something called as a market value which keep changing every year and all per year, no, sir. But
See,
instead of 51 lakhs, can we show it as 49 lakhs and avoid that TDS, sir?
there is something called circle rate or government rate or sub-registrar rates. It's called in these three. So the circle rate or government rate or sub-registrar rate are fixed by the government. Even let's assume the property value, government value is for 40 lakhs. If you are selling it for 35 lakhs, you still have to pay stamp duty for 40 lakhs only. You cannot reduce the stamp duty for 35 lakhs and pay for the government, because the government will not accept and it does not allow you for registration. You have to purchase stamp duty for 40 lakhs, then only they will allow you for selling the property. So let's assume the government value is 40 lakhs and the seller wants to sell it for 50 lakhs or more. So the purchaser will have to purchase stamp duty for 50 lakhs and above. So this is the practice.
So it should not go below the market value. The document should, even if you show it below the market value, you have to pay the stamp duty for the market price.
Correct.
If it is above market price, you have to pay for that higher price.
Correct. And some
Okay.
people, to avoid paying stamp duty, they pay some part in cash and they show for the exact government value to avoid paying additional tax. They will not show the higher value which they are purchasing. They will only show the sub-registrar guidance value, what is this, and they will tell when they approach sub-registrar to register sale deed. Suppose the property value is for 40 lakhs, they will only show 40 lakhs. The remaining, but seller would have agreed to sell it for 50 lakhs. They will pay 10 lakhs in cash to the seller and they will register only for 40 lakhs to avoid stamp duty. Such practice or people are also doing.
Sir, why is this three different rates? Is this because the rates are being distinguished between rural and the sub-rural or or the urban areas? Government rate or
Obviously, in urban areas, you're getting more amenities, correct?
Mhm.
So there's a different rates applicable for for change of khata the property tax may also increase in the urban areas compared to the rural areas.
Right, sir. That amenities are agree, but see why these three different rates? Why the government is fixing sub-register rate or a government value? At the end of the day, all these are government bodies, right?
Sir, I think you did not understand the point of sub-registrar rate. It is generally fixed by the government. Sub-registrar rate or circle rate or government guidance value, what it is called. So that is generally for any property in any area in Bangalore. It is any area in Karnataka. It's fixed by government. Even if you are selling before, even if you are selling lesser than that guidance value, you still are liable to pay for that exact guidance value. You are liable to pay stamp duty to register that property for that exact guidance value. Suppose it's 40 lakhs government value and you want to sell it for 35 lakhs, you are still liable to purchase stamp duty for 40 lakhs, 6.6% of 40 lakhs, and then you can go ahead for registration. If you are purchasing for only for 35 lakhs, they will outrightly reject your registration and they will not allow you to register.
Agree, sir. I got that point with the government value. So, what is the sub-register rate?
The same sub-registrar rate, guidance value is one and the same thing. And generally, consideration
sir,
value, it depends on the consideration value. Consideration value means the value on which you are purchasing the property. On that value, if it is higher than the government guidance value, you will purchase stamp duty for that higher amount. If it is lesser than the government guidance value, you will be purchasing stamp duty only on that government guidance value, but you cannot purchase stamp duty lesser than that.
Is this government guidance value will be reviewed every year or every 5 years? What
Every
is
3 years,
the
every 3 years, 4 years, it gets changed. And there is book. Sir, book idya? Subareddy sir. We have one book in our office. The government, yeah.
What's his name, sir?
This revised estimate market value of immovable properties and buildings. I think this is of a older version. This is of 2011. So generally it's available in the courts in city civil code. The latest version is available. So this is a older version. So in this book, every area in Bangalore and Karnataka, you can get the guidance value, government guidance value of the properties. In which area, which apartment, what is the value of each apartment. If it's mosaic flooring, it will be a different guidance value. If it is the roof, all those many factors come into consideration while deciding the government guidance value by the government.
Okay. Got it, sir. Sir, and one more question on the GPAs, right? So, I said we read somewhere in 2015 this GPA policy has been abolished due to this all this unnecessary or illegal transaction of the properties, right? Is this true or still the GPA holds good for all the properties?
Sir, unregistered GPA has no value in the eyes of law. But in today's scenario, if person is giving some power, creating rights for another person to interfere and sell the property, then he must have a registered power of attorney.
Okay. Sir, and one more question which I had when you said construction on the buildings, right? So I mean most of the buildings or like apartments or whatever you currently are building on the JD, right?
Yes.
Joint venture JV, joint venture property, sharing the
Yes.
property values, right? So, say for
Yes.
example, tomorrow, if there are any litigation arises between the developer and the landlord, right? So, how do we come to know as purchaser? I don't know what is going behind the scene, right? So only I will trust the builder, or I have a direct contact with the property owner. I will get in through with them and get his share registered to me. So what happens if someone come tomorrow client saying that today there are so many cases around, right? So how do we will come to know whether how do we as a buyer, what are the checklist I should be doing this, studying this? Because
See,
as you
it's
told, you have given your opinion based on the documents whatever were submitted to you, right? Say for example, there are some documents purposefully the builder or an landlord will not submit to you because at the end of the day he will be in urge of selling his property, right? So how do I as a buyer, how do we come to a conclusion saying that there is no such issues in these such properties? I know builders will not get into such properties because they will invest a lot of money, but as an out of my curiosity question.
straight simple answer is if builder is not ready to give such properties, don't buy the property. And there are many disputes and many where it is a safe bet to invest in occupancy certificate issued properties. If you are going to invest in properties which are under construction, then it's a risky affair. So it's
But
your call and
currently there are
decisions.
very
Because if
very less properties in.
Hmm.
Sorry, go ahead, sir.
So it's your decision and the advocate's decision, because what type, because generally people clients to save money they just want a smaller version of legal opinion only to check if the apartment titles on the copies the builder has given. On those copies, generally the people approach advocates to give a legal opinion. But if they want to have a detailed legal opinion over the land and other change of hands and joint development agreement and all those things, then the people should be ready to spend more for all the different offices. The advocate has to travel, get obtain documents and all those things. It depends upon the client perspective, how he wants a legal opinion to be generated.
Yeah. So usually getting into this joint venture, what are the
The joint venture, if tomorrow, because two examples I would like to quote nearby our college only, if you go 2-3 kilometers ahead, you will find Skylar Kitaka apartments. So there the big builder invested to construct the property. In the middle of the time, the landowners did not pay them sufficient money, and the builder who was in contract with JLL or DLL did not complete the apartment on time. Many people uh, and they had formed a company. Now the company is getting dissolved, and many agreement holders who entered into agreement with the builder, which is under construction, now they have implicated themselves in the dissolution of company process before National Company Law Tribunal. So some risks are available if builders do not complete on time. There are certain safeguards given by consumer court. Added interest is available as measure if you approach consumer court or RERA. uh, no, basic nominal, whatever additional interests you have been paying for not getting a home on time on due completion dates. Certain safeguards, certain landmark judgments have been given. But in this seminar, we cannot discuss all those in details. Maybe in coming days, we'll discuss.
all right, sir. Thank you.
Ali ma'am, any
Sir,
questions? Yeah.
is there any clauses for a joint venture in particular, or
Clauses,
any?
as in, I have to check that joint development agreement. What are the
Okay.
conditions?
So,
How much?
as per in the Transfer of Property Act, right? So are there any sections or laws or clauses or where
Not mix
we should be in particular?
transfer of property here and bring some. It is I am giving here a generalized view on giving legal opinion.
Okay.
Subject matter. Maybe in another seminar when we go in depth, because here I have just tried to showcase a basic version of legal opinion. Because this is a short form of legal opinion when the documents are very less. Because if they, when I have to give a detailed legal opinion, I will also try to conduct another seminar where I will try to showcase how I have checked each and every document. So that should help
Sure,
you
sure, sir.
in
Yeah.
learning.
Yeah, thanks a lot, sir. That will be
Okay.
helpful. Thank you. Looking forward to such session.
Okay, everybody understood today's topic, I believe so.
Yes, sir. It was very helpful, very informative. Thanks for all your help and support as always.
Stay in apartments, Jagdish sir.
No, sir. I'm staying in the independent house.
Okay. Okay. Okay.
Because I mean, a lot of my friends are going through all those things. So I just wanted to have a check on this. That's the.
It's a common thing everywhere in Bangalore.
Yeah. I mean, if you say like an occupancy certificate, half of the Bangalore cannot be occupied at all in the current market, right?
But does the builder is not having selling the apartment?
Yeah.
When RERA also, when the builder has to upload documents, you can just check on the builders. You can just check the builder's credentials on RERA website. What all documents he has uploaded. I have come across many cases wherein he has uploaded incomplete documents of plan sanction, plan approvals, land documents, and all those things. And even RERA has not come up with a guideline that what all documents needs to be submitted online for verification of residents. If resident wants to verify on RERA website about a property, even they are also getting incomplete information about the properties. This is the state where we are, because our law is still developing. We need to develop more and more things.
True. I agree, sir.
Okay. Thank you very much, everyone.
Thank you, sir. Thanks a lot.
Thank you, sir.
Yes, sir.